these are very interesting areas of law that people have expressed, the presenters made presentations in very interesting areas, very practical laws. So I think I thought you all will have more questions to ask from them, because
I would like to put forward a question to Ms. Sajivi and the joint author, our Dean of the faculty. You said the business judgment rule should be incorporated into the statute, but unlike in England or other countries, most of the other countries, we have a subjective standard in our section 189. And also because due to the absence of the component of diligence, our standard is quite low than UK. So don't you think the business judgment rule is impliedly incorporated into the Sri Lankan statute? And the second question is for Dr. Mahanamaheva. The purpose of codification of these directors' duties, section 189 and the fiduciary duties in 187, was done with the objective of making the law simpler and more accessible to people. But as I know, according to my understanding, our judges are heavily dependent upon common law, English common law cases as of now, and there are no any judgments specifically refers to our sections. So I want to know whether the purpose of codification has been successfully achieved as for now. Thank you.
Right. To address the issues raised by my colleague here, now I would like to point out that you said that the standard of care that you find in section 189 is a subjective standard. That was the very purpose of my research, the paper that I presented today, to tell you all that it should not be considered as a subjective standard. I pointed out that judges all throughout the world, especially in Australia and UK, have interpreted this duty to be a dual approach. That means it should not be considered as a subjective standard. Now that was the approach taken by Roma J in Ray City Equitable Finance Company case. So it has been rejected all over the world, actually throughout the time, through several case laws. Now the approach is that it's not a subjective standard anymore. It's an objective standard plus a subjective standard, which makes it a dual test. So what the director has to do is, first he has to prove that he has acted according to his knowledge, skill and experience. Then he has to prove that he has also shown the skill, knowledge and experience of a person who would hold a similar position, to show that he is entitled to the functions that the decisions taken by him hold in that position. And the other thing is that I think that explains, that answers your first question. The second one is, I would like to tell you that now, I think the question directed at Dr. Mahanamaheva also refers to this. The statutory duty of skill and care that you find in the Companies Act in section 189 is actually a codification of the common law. So that it's basically in section 190 also it's expressly provided that in addition to the statutory duties that you find in the Companies Act, you can refer to any other laws that are there prevalent. So it does not limit actually to the Sri Lankan decisions. Of course, when I started this study, I also tried to find whether there are any cases in Sri Lanka that were decided on directors' duties. Unfortunately, I could not find a single case that were decided in Sri Lanka based on not only in standard of care, not for any director's duty. Yeah. So we have to, in the absence of domestic laws, like I pointed out earlier, in the absence of domestic laws, we have to look at similar provisions that are there in the other jurisdictions and see how these provisions have been interpreted in these courts of those countries, and bring in them as, not as of course binding authorities, but as persuasive authorities. So common law duty has been codified in Sri Lanka in section 189. Definitely, we have to look at the common law case law developments. And also, since Our Companies Act today, what we have is not really based on England Act, but is modelled on New Zealand and Canadian Acts. I think we need to go further than England and also look at the New Zealand judgments and Canadian judgments. And the other thing is regarding implied incorporation of the business judgment rule in the section. I don't find anywhere in the section that refers to the business judgment rule. No protection is afforded to directors when it comes to directors' duties except section 218, where you find the insurance that is provided to directors. Other than that, no protection is there to protect innocent directors who take a risk in promotion of the success of the company under the Companies Act. And the other thing is, with all due respect to our courts, I would like to say implied incorporation is not sufficient. Why do we need to let it to the hands of, or rather the discussion of the courts? Why not introduce it in the statute itself? So that is my point of argument. We boast of having a very good Companies Act. So in that act, why can't we provide for a defense for these directors? Otherwise, my point is, directors will not take any innovative steps in running a business.
Adding to that, now if you see 1938 Act number 51 of Companies, 1982 Act number 17, where after the open economy introduced in Sri Lanka, the directors' duties were not actually, even they didn't start a discussion. So the freedom was given. Thereafter, our drafters, they looked 1993 New Zealand Company Act, 1985 Canadian Business and Corporation Act. So they were looking because you want to, now, as my experience, when I was practicing 1982 Act, it took more than months and months to register company. Company registrar returned my papers. Your primary objectives are not tally with your ancillary objectives. So today it's very easy. Online you can, within 24 hours, you can register company. That's why they have done. But when you see the codification of directors, as she correctly pointed out, the defenses are very, very important. Nowadays what will happen, there is an institute called, Mr. Sandhu Vijayamana knows very well, Directors Institution was set up. Because if any director, even honestly taken a decision, sometimes you don't have a defense. So get ready, 500,000 rupees plus imprisonment for 2 years. Then the insurance companies followed this. Now they have introduced, like Dr. Professor Pianiti Soisa's case, they introduced medical negligence insurance. Now there is an insurance called Directors' Duties Insurance. If something goes wrong, you can, basically, but practically, even many people even offered director post, they are not taking. But I like to add one, when I was working with Securities and Exchange Commission as a member, we have seen a lot of cases. Now one, what was the company registrar general told me, even independent directors are not there, you can draft your articles of association, where even one of my friends wanted to take a directorship, but he denied it, because nothing like that, executive, non-executive, they have not explained, but in the articles of association, the company director general told me, you can incorporate one. Not only innovative, because they are a little bit reluctant. Because I don't like even introducing a law for companies. Ethics are very important. If business ethics are working in a country, why we need a law? So, but if you try to restrict in such a way, there can be. But as pointed out, in Australia there are a lot of cases on business judgment rule. In Sri Lanka, yes, we have not seen, only the even insurance part only we have seen.
If I have to make some observation, if you look at our corporate history of the companies, we did not have so many companies collapsing in the past, because the directors practiced their ethics. Once you are appointed as a director, it was considered as a responsibility, it was considered as an honor to be invited as a director, and they discharged their duties to the best of their ability. They did not have to, the directors never had to be told, okay, if you have a difference of opinion, or if you disagree, you have a right to go to a lawyer and get an opinion, or you have a right to go to an accountant and get an opinion. and the company will pay for it. That was not there. It does not have to be written into the law, because the directors did that, because they consider this as an honor that has been bestowed, so they have to discharge their duties. They themselves went and met these people and got their advice. Today now, as you rightly said, insurance companies have come and given policies on directors. Most of the directors I know, their companies have taken this policy so that the directors are covered. Directors have been told, once you sit on the board, they have been told that you have a right to get a legal opinion. You can contact the company secretary if you disagree with any of these things, or if you want to consult a chartered accountant, get in touch with the company secretary who will arrange to get an independent opinion for you. So all these things now have to be brought in, because we don't go back into that ethical practice that was there within the system. With the open economy, more companies came, more people became directors. They did not understand what the duties of a director is, and this whole thing has deteriorated. So let us get back to the old level of the position of a director, and by that all these things will fall into position. So that is my observation that I would like to make on those questions. Any more questions? Yes, please.
Thank you very much. It's just a comment to the lady who spoke about the banking industry. Lady, you said that the Pramukha Bank had no Parate execution rights. So every bank that is registered in Sri Lanka and who has the license to operate as a bank has the right to execute Parate action. So first you have to find out, though they call themselves a bank, whether they had the banking license. For an example, Merchant Bank of Sri Lanka, prior to the merger, though they call themselves a bank, they only had the finance leasing they only had the leasing certificate to operate as a finance leasing company. Now they are they are not only a leasing company, presently they are a financial institution as well. So if it's a bank, they have the right to execute Parate action. If it's a financial, if it's a company registered under the Finance Act, they have the right to execute the mortgage bond action. That's one thing. Second thing, you said you propose a special unit to investigate or to see to the operations of the banks and the financial institutions. There is already a unit at the central bank called the Banking and Financial Institutions Supervision Unit. They have specific rules and regulations. Every year they print a booklet with the rules and regulations, and they require, there are several rules, such as they require every bank to have 4 audit committee meetings every year, 12 board meetings every year, 12 audit committee meetings every year, and 4 risk management committee meetings every year. And there is a requirement to have a compliance officer in each and every bank and a finance institution. So this compliance officer has to send a report every month to the central bank. In this particular report, all the details have to be included. So I think we have a separate unit. I think Dr. Vijayamana will explain further. Apart from that, I came across another issue. Yes, you spoke about the banking and the financial industry. I wished that you touched upon this consolidation process that was introduced in 2014. Am I correct, President's Council, Chandana? Yes, consolidation process. So that's something new to the country. That is under the guidelines of the central bank, and the consolidation process was taken place under the guidelines of the central bank, and it was implemented under the rules and under the provisions of the Companies Law Act. I think President's Council Chandana will be able to give a little guideline on that. Thank you.
Okay, let me just, before we wind up, let me just make this observation. With regard to Pramukha, what she said, let me explain to you because I have been in the banking industry for this thing. Pramukha was a licensed specialized bank. The Parate law, when it was introduced, they gave the Parate rights to all the commercial banks and they named the licensed specialized banks that were given the Parate rights, like DFCC, the NDB, and so forth. So therefore, at the time when Pramukha came into operation, they did not have the Parate rights. Subsequently, if they became the law has been amended. Then, as you rightfully said, there are two directors in the central bank called the Director of Bank Supervision and Director of Non-Banking Supervision. So, Director of Bank Supervision is who is looking after the banking sector of this thing. All audits have been done under Director of Bank Supervision, and Director of Non-Banking Supervision goes under finance companies and leasing companies, and now is again, I think the microfinance companies also falls into that category. With regard to consolidation process, the banks, there was a plan the central bank had, and the central bank also gave the companies to come into consolidation. But I think now the central bank's thinking is little different. The consolidation that was to take place in that manner, I don't think is going to take place in the future, but there will be certain consolidations that are taking place today, but not in the same manner it acted. It is true that the country needs strong financial institutions, but at the same time, the country also needs what we call competition among the businesses. One of the reasons why the finance companies became very, very active is because of the access to the banks by the business community was limited. The people with a who does not have a strong balance sheet could not go to the banks and borrow. So they are the people who started going to these finance companies. And when you go to these finance companies, you have certain amount of higher rates of interest as well as certain other conditions, but nevertheless that also provides a service. So I don't think the society needs not only banks and strong finance companies, but the society needs leasing, hire purchase, microfinance and banks, and even I say development banks and even what we call investment banks. So the whole industry, the banking industry is required. So with that we are almost half an hour behind schedule. So let me thank the 5 presenters for the excellent work they have done, and also thank all of you for the active participation. And let me close this. Thank you.
I would like to thank all the presenters for sharing with us your immense knowledge. And also I would like to thank Mr. Tushanta Wijayamana for your very valuable comments on the presentation. We would now like to award certificates to all the presenters of the session, and for that I respectfully invite the Honorable Chair, Mr. Tushanta Wijayamana, to do the honors. VSN Dilanerol. CS Gunasekara. A. Edirisingha. Y. Vijayaratna. GAC Sajivi and SWP Mahanamaheva.
Please remain on the stage, sir. As a token of respect and appreciation, we would like to present mementos to the Honorable Chairperson. I cordially invite Professor T.R. Veerasurya, the Deputy Vice Chancellor Academic of General Sir John Kotalawala Defence University, to do the honours. Thank you, sirs. With that, we conclude the session, and we warmly invite all of you to join the refreshments arranged outside.